calm down here. You have access to Fidelity's 13-month CRES Advantage Home Warranty Plus plan and Disclosure Sources CRES NAC plan. Why is this beneficial? Well, placing the CRES home warranty on a transaction could qualify you or your sellers for $50,000 of errors and omissions lawsuit and protection. Remember, fraud is never covered by any type of errors and omissions insurance. And then in the event they are named in a lawsuit after the close of escrow. So if you represent the buyers, the home warranty gives you, all right, gives them peace of mind with 13 months of coverage. And I'm assuming your fees are commensurate with everybody else's that. So whether you represent the buyers or sellers, placing a CRES home warranty on the transaction could qualify you for a deductible reduction of up to $5,000 on your E&O policy. That's very important. So if you want more coverage for your sellers, you can add a CRES NHD disclosure source, and or your sellers could qualify for an additional $25,000 of errors and omissions insurance lawsuit protection. So combining the CRES NHD and CRES home warranty, and your sellers could qualify for $75,000 of errors and omissions protection. So to provide you more information and to talk about other aspects associated with risk management, right?
Yes.
Is Sharon Whaley from National Home Warranty. Fidelity, right?
Yes.
Welcome.
I'm so happy to be in this office. I've been your rep for 28 years, and this is my first time they've let me in. So thank you guys for that. I hope you're enjoying your breakfast and your pancakes and everything. This flyer that he gave you, this is something you can take with you, that everything he just said, you can read again, so you have it later as a reference. It's very important, though, when you go on a listing presentation and you tell your sellers you're going to give them $50,000 or $75,000 in E&O coverage, you absolutely must order a CRES plan to get that. Because if you let somebody put something in and you go with another company that doesn't have it, they won't have that coverage. And then guess who's going to be liable? You know, they're going to come back to you if something happens. So make sure if you talk to your sellers about the $50,000 in coverage or the $75,000 in coverage, you absolutely make sure a CRES plan gets ordered. That's something that always worries me when we talk about that. And I just want to make sure you understand it. Okay, there's another flyer she gave you, and this is, I'm just briefly going to hit on. We do a lot of things that other companies don't do. This is a good thing to go over. Briefly on the front, in the back, you see the 5 plans and what's included in them. My thing is this Enhanced Plus plan is by far the best in the industry. And I'm going to tell you, if you look down, you're going to see all the options included in it. Yes, it's pricey, but it covers things other companies won't touch. So yes, you might want to pay a little more up front, but it can save your clients thousands, and I mean a lot of thousands in, you know, if they have a problem. So that's it. I'm always here to call. You can call me, text me, email me. I'm really good at getting back to you. And I'm going to turn it over here to Dave, who's going to tell you what they're doing.
Okay.
There you go, Dave. Take it away.
Dave. Mark, this is your opportunity to impress us.
All right, we'll do our best.
Well, you guys did a great intro there. Was that Carlos or Richard that was doing the explanation of the benefits? That we should hire you because you do it really well.
That was Richard.
Oh, okay, that was Richard. Well, great job, Richard. Just phenomenal. So obviously there's advantages because your office is with CRES for the E&O insurance, using Sharon and her NHD report and her home warranty program. We had mentioned this morning that Mark had been here a couple years ago. We're going to run through just a risk management webinar for you guys, just to kind of give you an update of what's going on in the marketplace. We are on kind of a hard stop at 11. I think Mark and I both have other meetings that we need to get to, but happy to welcome in Mark Carlson of the Carlson Law Group. Mark has been litigating real estate E&O claims for over 30 years, which means you're kind of a Doogie Howser. You started at what, 12, 13? Right around?
Yeah, that's right.
Yeah, exactly.
Fast track to law school.
Exactly. And of course, his law firm works with CRES Insurance. So CRES Insurance has an E&O claim and they send it over to Mark's firm to litigate. So Mark, welcome. How are you?
I'm doing well, thank you. Good to see everybody again. Actually, Richard, now that you mentioned, I do remember the seminar because from your office, I went down for a nice weekend in San Diego.
Well, thank you, Mark.
That's fantastic. Mark, what's going on in the current real estate E&O claims market? Have we seen an increase or a decrease from last year or maybe the last 3 years?
I would say in the last 6 months that claims have really started to increase, have a little uptick. And the carrier clients that we deal with are telling us the same thing. We're seeing more files come our way, and I don't really have a good answer for why that is, other than maybe, we usually see claims, 18 months to a little more than 2 years after there's changes in the marketplace. And so I guess, when the market in a lot of areas was, there was a lot of activity, a couple of years ago, when maybe that's the cause. I don't know, but there certainly has been an increase in the last 6 months.
I've always had this weird theory that now we're in a market with higher inventory, right? Higher than before, higher home prices and higher interest rates. And I feel like buyers that move into a house now, they don't have the pockets to, replace an HVAC system or do some huge expansion or maybe some changes to the yard or maybe a roof or something like that. And it seems like back in the day when the market was crazy, there was little inventory and money was cheap to borrow. They were just so happy to get that house. Maybe they wouldn't raise their hand so much for a claim. Whereas now those conditions are, they don't have that extra money when they've come into the house. Am I crazy on that?
I think there's certainly been an inverse relationship with equity and lawsuits. The more that the market increases after a sale and therefore increasing the buyer's equity, they typically don't file lawsuits as frequently in that environment. When money's tight and the market is slow, if there is a problem like you're mentioning, that usually results in a higher frequency of lawsuits. So yeah, I think that the strength of the market as far as increase in prices certainly has a relationship to claims.
Yeah, it makes sense. I mean, if I move into a house and all of a sudden now I'm hit with a $20,000 HVAC system that maybe they didn't disclose something about, I could raise my hand and say, you didn't tell me this. I don't have the 20 grand. Or I could have bought 3 houses down the street that maybe didn't have this issue. So seems like to me they just kind of correlate. But in the end of the day, what really drives E&O claims? Is it new forms, new laws, or is it just people?
Yeah, I think I don't know that there's any change in the industry that results in litigation. I know we thought that there was going to be a lot of litigation after the NAR settlement, and we really haven't seen that. Things sort of, the frequency of claims, it really, like I said, is more driven by the economy than it is any particular change in regulations or laws or anything else within the industry, and we're gonna get to this, but I'll foreshadow, the vast majority of all claims has always been and probably will forever be disclosure items, things about a property that a buyer finds out afterwards and is unhappy about.
You mentioned you're getting an uptick in calls through the risk management hotline on the BRBC, which is the Buyer Representation and Broker Compensation Agreement. And that outlines the terms of the representation, including the scope of services, the duration, and compensation for the agent. Why are you getting a bunch of calls there? Kind of walk us through what we should know there.
Well, I'm not making it up, but you probably aren't going to believe this. But it's just selling agents having invalid BRBCs. They have a term that's greater than 2 months, or they don't put any commission in. And I'm getting calls all the time from broker clients where either in 2 scenarios they find out that there's an invalid BRBC in the middle of the transaction, and then they come to me for guidance on how to fix it. Or even more difficult to resolve is after the transaction's closed and all the commissions are paid and the broker's doing the audit of the file afterwards and finds out that the BRBC is invalid. And so, if there's, I hope everybody, I'm just saying it in the room to identify the 300-pound gorilla that this is. If your BRBC is invalid, you potentially are going to work for free. Because the 3G3 of the purchase contract says that the seller concession on commission can't be greater than what's in the BRBC. And if you have a BRBC that's invalid or doesn't state an amount of commission, then the seller could certainly say, well, I'm not paying anything. And now you've got an invalid BRBC with the buyer. So all those protections that are in the BRBC, if a buyer accepts an offer where the seller doesn't agree to give a commission concession, you're going to be working for free.
You'd mentioned earlier that there was a 3 and a 6 months trigger. You were seeing some issues with them being 6 months. That's not valid, is it?
No. Anything, yeah, it's anything over 2 months is invalid in a BRBC. So people, I think, are maybe just doing it like they would a listing agreement. I don't know, but it really is a frequent problem, and you wouldn't think it would be because it's been around for more than a year now.
Right. Now, those folks that have called into the hotline, are they leaving the call more comfortable with that situation, or are they screwing those up?
No, I mean, usually it's the broker that's calling me that says, okay, I've got this problem. How do I fix it?
Right.
And we've got, from very large brokers to small brokerages that call on the risk management lines. It isn't in geographic. It isn't limited to one area or another. It's all over the place. So it's
Okay.
and even with some seminars that I'll go give, I frequently will hear brokers remind their agents about this issue.
Perfect. Well, we're going to have a little Q&A at the end. So if you have any questions from the Zoom or in the room there, Sharon, you can help us monitor that. We'll be happy to answer some questions, hopefully around 10:40. That gives us about 20 minutes to answer some questions. Mark, you had mentioned you had been to the CAR meetings recently, and now they're kind of working with an issue, maybe with the DRE regulations as it's to a transaction coordinator. Sorry, transaction coordinators, and maybe them having some new DRE regulations. Can you tell us what you heard about that and maybe what we might see down the pipe?
Yeah, so there's me back up. I think I misspoke a minute ago. I said 2 months. It's 3 months on the BRBC, just so that we're clear. But yeah, so at the CAR meetings that happened toward the end of April, I was up there. I was in a strategic defense strategy committee meeting with a bunch that's made up of a bunch of chairs of other committees, and they had Stephen Lerner with the DRE. He's one of the top deputies there, and then also one of the staff attorneys, very senior, who I'm forgetting her name. I'm glad she's not on the call. And so, firstly, this issue about the BRBC came up, and unfortunately, neither one of them had a good solution for what happens when when the post audit after commission is paid, that they find to be an invalid BRBC, and so that really is sort of been a motivation is a motivation of the DRE to develop some regulations that they're working on that maybe they'll come out next year, maybe 2 years. DRE doesn't work fast. But they recognize that there is things in the settlement agreement, terms of the settlement agreement that aren't necessarily the same as the new laws that have been passed, and so there are going to be some regulations that help people try to navigate through this. Counting days. There's a multitude of things that they're working on. Also, they're working on regulations for transaction coordinators to try to give some clarity as to what a transaction coordinator can lawfully do or not. If you look on the DRE's website, there are a number of memos and letters that talk about unlicensed assistants, and then also talk about transaction coordinators, and they're not all consistent. So they recognize that there's a problem or a hole in the marketplace for some guidance from the DRE on those issues, and so they are looking to try to fix that up. So be on the lookout. There'll be some pretty poignant when they come out. They're going to be pretty poignant on regulating a lot of things that brokers do relative to the settlement and on this transaction, the NAR settlement and this transaction coordinator issue.
Now, for an agent, what this means for them, if they have an office like Coldwell Banker here, if they have an in-house transaction coordinator that is employed by Coldwell Banker, they fall under the E&O insurance. If they're using a transaction coordinator, or any agent using a transaction coordinator that has their own company, should they require them to carry E&O insurance? Do they get named in lawsuits?
Well, they get named when, when there's a mistake, and if this transaction coordinator that makes the mistake, they'll get named along with the agent. Keep it in mind, the fiduciary is the agent. It is not the transaction coordinator, and that's, I think, a lot of agents have the feeling that if their transaction coordinator does something wrong, it's not their fault. But in this area, the what flows uphill. It doesn't flow downhill. And so if there's a mistake made by your transaction coordinator, you as the agent are going to be responsible. And so if you're using somebody that's outside the office, it always is a good idea to have to make sure that they carry their own policy.
Perfect. Let's go through a few hot topics. And it's so funny because I think we've been literally talking about this one for 8 years and it's still on the top of your list. And, we had a lunch last week and talked about this. And you said it just came up again, but wire fraud and the scams that are happening with them changing a little bit of the email address. Tell us the madness there.
Yeah, they're wire fraud. I always have 2 or 3 wire fraud cases open in my office. It's not going away. They're getting more sophisticated. The one tip that I think is the most important. Well, there's 2 things. I would call them 1A and 1B as far as importance on wire fraud. The first is read the wire fraud advisory to your clients. It isn't just another form to stick on the back of everything and have it be a forgotten item, because it's very good about telling sellers and buyers how wire fraud is perpetrated, and so that they can be on the lookout for it. And just last week, the day before, you and I did another one. Dave, you remember one of these? I had a broker client call me, and they had somebody hacked into one of their agents' email account, sent an email to the buyer to where to wire the initial deposit. And it was literally on the afternoon of the morning when the agent sent the buyer a real email that says, listen, you're going to be contacted by escrow to get the wire information. Here's her name, and he copied the signature block off of the escrow officer's email, and then of course the wire fraud advisory says don't take instructions from your agent. Wire is always going to come from title or escrow. And so literally within a few hours, he gets this cryptic email that there's no capitalization, there's no punctuation, the grammar was horrible, and it said use a Gmail account because the escrow likes to have more security. And the guy, without calling anybody, sends the wire off to Nigeria or wherever it went. And so the other part of this is, again, nobody should be using Yahoo accounts, Gmail accounts, anything of those, Hotmail, or if people are still using AOL, it does exist, but don't use those kind of accounts, because what people will do is that they will, when they hack and find out about a potential wire, they will, if they get into your account, they will create a rule that has all the legitimate emails from the parties to the transaction go into trash so that you don't see them. And then what they do is they go on to Gmail, let's say, and they will create an email account that's nearly identical to whatever you're using. So if it's, and I'm not picking on Harriet, but Harriet's name, Halooms, is a great example. Instead of having 2 R's, maybe they put 3 R's, or maybe instead of 2 L's, they put 3 L's. And the human eye, and on the cases that I've tried, the IT experts all agree that the human eye takes less than 1/10 of a second looking at an email address when it comes in. Then they get to the body of the address. So the people miss it, and then everything else about the email is exactly the same. They'll get your photograph, they get your logo, all your email addresses. If you have any designations, they copy it identical so that the parties can't tell that it's not you. And then what they'll do is they'll monitor the emails, and they'll get pieces of information through other things that have nothing to do with the wire. So let's say that you've emailed there's been emails about looking at some other properties, and so the fraudsters will send a fake email to the buyer and will include information about the other properties that you had been talking to them about. So that way the buyer thinks that it's really coming from you. And then what they will also do after the wire get sent, they'll stay engaged for a day or two, so that get some space between the fraudulent wire and when you ultimately detect it, so that there's no way to call it back. Because if you don't recall a wire within 24 hours, typically there's no way you can get it back. So use the office email account. If you don't have an office email account, create your own domain name. It's really easy. You can go on to GoDaddy and get it done in 15 minutes. It's like $20 a year to get your own domain name. And then that way they don't have the ability to, the fraudsters don't have the ability to create a fake email. Although all the cases that I've had, with the exception of this last one, where they hacked into the account, into the company account, that's the only one out of probably 2 or 3 dozen of these lawsuits that I've had over the years where they didn't use a Yahoo or a Gmail account.
Crazy. And we see a lot of times when we order home warranties through escrow companies that they have an advisory below about wire fraud. And if you didn't get it from us or a phone call, is this them protecting themselves too?
Well, so certainly in your signature line, you should put a statement that says, don't respond only to wire requests by email. Call me if I send you an email that has wire information or request for wire, something along those lines. Because a lot of times what will happen is that the fraudsters will copy all of your information except for that signature line. And there's a new case that actually just came out at the end of May of this year that says that the liability for a fraudulent wire transfer is going to be imposed upon the person who is in the best position to have recognized the fraud. So if you have a company email account, if you have that signature line at the bottom that says, don't accept any wire instructions via email from me, call me before you send a wire, and that doesn't appear on the fraudulent emails, then you're going to be able to say, well, listen, you received however many emails from me before that had that statement, and now all of a sudden you get an email allegedly from me that doesn't have it. You should have called, you should have realized that was a fraudulent email. So if just little steps that you can do to make sure that that you are doing more than everybody else is going to elevate you to the top of the line as to who gets the most protection in a wire fraud case. If you're not doing any of those things, then it's going to be really difficult to defend, to say that you didn't do enough to be able to stop a fraudulent wire.
Just crazy, because I know we're not talking about $10,000 or $15,000. We're talking anywhere from 50 to $200,000, $300,000, $400,000.
Yeah, they're usually are big,
life-changing. Yeah, just life-changing. Mark, you've always told everybody, and there's no surprise in the room there, that 95% of lawsuits, lawsuits, are buyers suing sellers. That's why Sharon and Sandy there, they've always preached the value of a home warranty, because a home warranty keeps the buyers happier after the close of escrow. So maybe they're less likely to want to name the sellers in a lawsuit. But we know that 95% of buyers suing sellers. You mentioned permits and even water intrusion are pretty high up on the list right now. But give us an example of 3, 4 ways that a buyer would be suing a seller for non-disclosure.
Oh, well, I mean, it's too varied to whittle down to the top 3. It's always clearly people get agitated with water, so they buy a house in the summertime. First rain comes and the roof leaks. So those are the ones that usually get filed first. But if you it can be anything that deals with how something with a property might go wrong. The settlements in a soil subsidence, lot lines. It just is whatever can go wrong with a house is typical. Can be the subject of a non-disclosure case, and that's why. Going over the SPQ with your sellers carefully to make sure that they remember things, and getting, if you're representing a buyer, if your home inspector says, you might want to get a roof inspection, get a roof inspection, because those are if you've done it, not just from a liability perspective, but to be able to be diligent in finding out or investigating a property to hopefully discover a problem before close of escrow. Obviously, that's the best way to resolve those, or to avoid getting sued. because if something comes up during escrow and the buyer says, okay, I'm okay with it, or gets a price concession, we don't see a whole lot of litigation in that scenario. We usually see, a buyer gets into a house and bad things start happening, and then they don't get, the seller doesn't want to pay them any money after close of escrow, and then that's when they end up suing.
Right. You've even mentioned school districts have been an issue. Maybe when a purchaser bought a house thinking it was in this school district and maybe either realigned or they found out later it was in another school district. And
yeah, those are another set of disclosure issues where the buyer is again wants to be in a particular school district and mistakenly believes that the property they're buying is when it turns out not to be, or the buyer wants to buy a property to park their boat. And there's recreational vehicle restrictions in the CC&Rs that nobody catches prior to close of escrow, or wants to rent out the property and is in a condo that does association that doesn't allow a certain number of rentals. So yeah, those being diligent about looking at the CC&Rs, and that really gets to be a problem because most escrow companies now will just go to the HOA directly and get all those documents, and a lot of times the selling agent doesn't see them. And so you need to make sure that at the very least, as a selling agent, if you have a buyer that is going to be using a property in a certain way, to at the very least get a copy of the table of contents to the CC&Rs, because they're usually pretty easy to figure out what's in there by looking at the table of contents. And if there is a restriction on a particular use, then you obviously want to make sure that the buyer reads it and is satisfied that as to what they can do with the property, what they want to do with the property.
Are you seeing lawsuits on square footage? I mean, that can be pretty costly when it's off by 1 or 2 or even 300 feet, or if something maybe isn't to code and can't now be counted in the square footage, and now maybe the home's worth $16,000 less.
Yeah,
what's your advice on that?
Yeah, so the scenario that's the hardest for us to defend is when you look at a historical the data in the MLS, and it shows that, and there's different square footages for the property along the way. I mean, we had one a few years ago where we represented the company that the property sold like 7 times within a 10-year period, something ridiculously high like that. And our folks had the pleasure of being involved in 5 of those 7 transactions, and in each one of those transactions, the square footage in the MLS was a little bit different. And so it's like, well, okay, maybe it's not required of an agent to go and measure a house, but when you at least go back and look at the historic data, you see that there's discrepancies. It's hard to justify not at least pointing it out. Hey, last time this thing was in the MLS, it was 1,500 square feet. Now it's 1620. Where did the extra square footage come from?
And then you've always said too that if there is a discrepancy, the square footage is deemed to be reliable but will not be verified. What was your wordage on that? I always like that.
So, well, 2 things. Firstly, that's just part of most MLS. They have a disclaimer that it's reliable but not guaranteed. But the most important thing was when you're putting in as a listing agent, putting in the square footage, there's boxes per seller, per assessor, other. And so if you as a listing agent identify where you're getting the number from, then that helps insulate you from not making an affirmative representation of fact. You're just passing along data, and there's not it isn't a statement from you that, okay, hey, this is what the square footage is. It's just, hey, this is what the seller says the square footage is, and that statement isn't by itself actionable.
Right. Now, back on this philosophy of 95% of lawsuits are buyers suing sellers, what about that 5%? What are some examples of buyers agents who think they might just be off the hook in a real estate transaction, but they do get named in lawsuits? What type of lawsuits are you seeing on that side?
Well, when the sellers sue, I think the most frequent suit is where the seller believes after close of escrow that the property was undersold, and so that happens a lot less frequently now, because with clear cooperation, since May of 20, you've been having to put the property into the MLS, shortly after you get the listing. But in the days prior, sometimes it gets held off for a variety of reasons, and then the seller argues that because of lack of market exposure, they didn't get the right price. So those are usually the most common. Of course, then you have some situations where the buyer will back out, and then the seller will try to sue because they can't find somebody else right behind to take the property at the same price, and argue, especially if there's a late disclosure or an incomplete disclosure, and then that causes the buyer to back out. And that's kind of scenarios where you would see a seller suing the agents, arguing because of their mistake. It allowed the buyer to back out, and then they want the deposit from the buyer, or what they want the deposit that the buyer would have had put into escrow. Not very frequent, but it does happen.
You ever get discrimination lawsuits? I asked you to find me a house in that neighborhood, and you said there was nothing available, and now all of a sudden, once I bought this house, I see that there were two available. You ever get anything like that?
Well, those are more just direct actions, from housing authorities, and they have people out there that are still doing, what they call test calls. They'll call and ask about, do you take Section 8? My name is Martinez. Can you show me houses in this particular area? And then they'll have somebody else call back and say, this is I'm the Campbells. Can you show me houses in this area? And then if the agent shows different houses to the Martinez's that they show to the Campbells, then they file, a discrimination claim. So there are people that are out there doing those testings, and also on service animals. So if you get a call or get a text from somebody and they ask about rentals with Section 8, or they ask about service animals, obviously the best answer is submit your application. We'll let the seller know. Don't say yes, don't say no about any of those, directly to those questions. And they're difficult because the way that it happens is the housing authority, whether it's in the LA County or the state, will assign an investigator who becomes your mediator. And then if you don't settle the case, you don't pay off the complainant, then that person becomes your hearing officer. And so if they don't think you acted reasonably in trying to resolve the case, then obviously they're the ones that are or could potentially have a bias against you when they're trying to hear the claim.
Just crazy. We talked about negligent referrals before, and I know we have about 10 minutes left, so I want to make sure we end on time. We've had agents in the past worried to recommend a service, even like a home warranty company, because they feel like it could come back on them. What's your thoughts on that?
Well, so there's two aspects of that. Firstly, you want to have a team of vendors, I'll call them, or support people for what you do, inspectors, escrow, title folks that are going to give the kind of service that you like to give, to the degree that you like to give. And so it's important to have a number of those folks that you trust in your transactions, so that everything runs smoothly. The ultimate test of liability on a referral is whether or not you referred somebody that you knew was not competent to do the job. And that's obviously a high standard, right? I mean, a home inspector they're not licensed, but they have some certifications. But so, as far as the liability, it isn't, they're never good claims on a negligent referral. But, if you're wanting to avoid litigation, you're not looking at the end of the line. Okay, am I going to defend this? You want to be, at the front of the line. You want to be the fence at the top of the hill, not the ambulance at the bottom of the hill. And so if you have folks that are competent and very professional, that's always the best, those are the best people to refer to. And then, like with home inspectors or roofers, it's always good to have a list of two or three, and say to if you have a written list, give to your clients to say, okay, here's a home inspector or a roofer that my other clients have told me that they've had good experiences with. So you're not giving a particular endorsement, and that really, is if you had that process in all of your transactions, it's going to be very difficult for someone to mount a negligent referral. But again, if you're going to give three home inspectors, make sure that they're three quality home inspectors. Don't feel compelled to put somebody on the list just so that you have a list. You want to make sure that the people you're going to be referring are going to do a good job.
We know that ADUs have become pretty pretty big in the last 2-3 years, and I guess the laws changed in, what was it, 2018 and 19, which allowed for a lot more of those. But then there's been more recent laws in California that essentially says anybody can have one. I feel like what typical
Yeah.
claims are you
Well,
seeing on those? Give us your pulse on ADUs, because
yeah, so long as you're within 5 miles of a bus stop, it seems you can do anything you want on your property nowadays. So ADUs have been it's been a hot topic. We've had a lot of litigation this last year, or maybe not quite a year. Since the fall, I really started seeing an uptick in those, and it could be because that 24 months that of changes in market conditions that result in claims. You had ADUs that the rules that became much looser and in the 17, 18, 19 time frame, and then maybe a little bit of time for sellers or buyers, owners to understand the process. Then they got to build them, then they sell them off, and so we're really starting to see an uptick in those kind of claims. And for ADUs, the issues are typically twofold. Either the permitting isn't done properly or not finalized. And so you're advertising in the MLS that something is an ADU and it's not. And probably there's folks in the room that have been doing this long enough to where I remember that infamous Fred Sands case where they got really hammered by calling another unit, another structure on the property a guest house when it really wasn't permitted to be a dwelling unit. And so if you're advertising it as an ADU, you're advertising it as a guest house and it's not, and then that's going to be a representation, or could be considered a representation that everything is legal with that structure. Then when they find out that it's not, then you're going to be named in the lawsuit as well. So make sure you find out, get the seller to verify that all the permits on an ADU have been pulled and finalized. And then another thing, try to be ask questions about what the structure was before it became an ADU. I mean, if it wasn't built from the ground up, because we've had one that everybody's going to chuckle at this, but it seriously was a chicken coop, and then they turned it into an ADU. And obviously, you're not going to have 16-inch studs on center in a chicken coop. They're built in a much different way. And then, you start hanging drywall and siding to make it look good. And then, the wind blows and the whole thing moves around a little bit. So, make sure that you understand how it was, the ADU was actually constructed, because buyers are getting in after the fact. They find out that it wasn't built properly, or it wasn't properly permitted. And those are the kind of lawsuits we're seeing on ADUs. And those become to be expensive, because now where the buyer maybe was looking to have the ADU just to house the in-laws when they came over and to stay a couple of times a year. Now all of a sudden, after close of escrow, they start making the allegation that they were going to use it as a rental, and then now they're making a claim for the 1,200, 1,800, whatever it is a month rent. Over 30 years that they're not able to enjoy, and those claims get to be pretty significant. And then just the last point to close out ADUs, for you listing agents that have clients that maybe have a structure on the property that's been used as a dwelling unit. People are using ADUs now to fix those kind of issues, whereas before they would never be able to have a garage that was converted into a living space to get that fixed. You can get them fixed now with ADUs, and then that's with the ADU laws, and that is adding value to properties and eliminating a problem that prior to that the seller really wouldn't be able to fix without tearing it down or converting it back to what it was.
Lastly, let's talk about just a home warranty real quick. I know because Sharon's in the office there. Obviously, she's with Fidelity National Home Warranty. We talked about most lawsuits are buyers suing sellers, but yet a home warranty protects the buyers after the close of escrow for that HVAC, the plumbing, the electrical, the dishwasher, range, oven, microwave. You see a ton of E&O claims. I mean, could you even put a number on what percentage of those maybe would have gone away with a good home warranty plan? You've always said that a home warranty plan is a good risk management tool. Just kind of give us your flavor there.
Well, so, keep it in mind, the ones where people are happy because they were able to get a problem fixed by their home warranty, those don't result in claims. I don't see those. But I do, of course, see, we do We do 70 to 80 risk management calls a month through the various risk management providers that we do partner with, and we get calls there, where, hey, there's a problem, the buyer has this issue, and a lot of times, we're able to make some recommendations to remind them to make a home warranty claim, and then those can go away. Another thing that is very helpful is where the seller has coverage, and where a buyer is suing for something that only the seller would have known, and pet urine, whatever, noisy neighbor. Now there's money there that can be used to help resolve that claim, and it doesn't come off of the out of the agent's deductibles, or off of their loss ratios. So extending those coverages because they're normally 6 months, but you can extend them because usually claims don't come up within 6 months. It takes a while for things to identify themselves, and then of course there's a bit of argument before they file a lawsuit. So having those seller protection programs extended, and having money there often is a way to help minimize the exposure to the agents. And for the record, I don't get a kickback on any of that. They don't even send the seller protection things to me. So I have no skin in that game, other than just trying to share my observations of how that's been helpful to agents, in my experiences over the years.
Well, we appreciate that. I think if you guys are wondering about the extension of the seller's protection plan, and I think Richard mentioned it up front, that if you put the CRES home warranty on the transaction, you could qualify the sellers for $50,000 of E&O. Well, that's free, and it's for the first 180 days from the close of escrow. So if you would like to extend it for another 180 days, and a lot of listing agents do it as a closing gift, you can send in $200 to CRES, and now those sellers will be protected for 380 days after the close of escrow on the home warranty. And if you're ordering the CRES NHD, it's $25,000 of E&O for them. For 180 days, it's free. You could also extend that for 180 days, so they would have 360 days. If you have both products on the transaction, I recommend just extending the home warranty one, because it's $50,000. It's better than the $25,000, but 75 grand is a lot of coverage for that seller. That more than meets the average lawsuit these days, right, Mark? Is around 19 to 21,000 ish.
Yeah, well, yes, I haven't run the math recently, but yes, the typical claim is in that high teens, low 20s, across all the litigation that most carriers have to cover.
And we're not going to go down a rabbit hole, but dual agency is closer to about 45,000 from what I understand. It's a little bit double.
Yeah, well, there's only one pocket to pick from, so that's
that's right. Well, Sharon, we're going to turn it back over to you because again, we do have a hard stop because Mark has another call, arbitration, I think is what he said. But we want to turn it over to the room there, or anybody on Zoom that might have a question for Mark.
Does anybody have questions? You're kidding. I don't believe that for a moment.
Do you know what Mark charges an hour? Come on, this is free. Free. Ask him a question.
Yes, go ahead.
I have a house I'm going to sell. It's a condo, and the garage is not her garage. We're selling that house. So basically, I guess she was given, like, let's say number 36, and her actual garage, we found out, is number 33. So when I go to sell it, what do I do with that if somebody else owns 33 versus 36?
So I'm gonna recap that for you, Mark. We have a
Sure.
client that in the past bought a condominium, and the assigned parking structure, parking garage, as defined by the condominium plan, was not given to the buyer. And the buyer was told it was a different garage that was assigned, and now someone else has been occupying that property. So she's saying, what do I do when I want to sell this? Because obviously the buyer does not want to litigate this in regards to recovering the usage of the assigned parking spot.
Yeah, well, so I in that kind of weird scenario, that obviously is a unique fact pattern.
And that was before Coldwell Banker, right? I just want to clarify that.
Right. I think the best thing really to do is, now when, The buyer obviously, or it sounds like, is not in the process of selling. I would work to try to get that issue resolved. Maybe hire an attorney that specializes in HOA issues, and then whatever the resolution may be, then that would be part of the disclosure packet when the buyer would go to at the time the buyer decides to sell the property.
So nothing new there. Yeah.
So we have to,
You're gonna have to litigate it, apply title action with the HOA, possibly. I think
Yeah, that's awfully strange that I don't know that I've ever seen CC&Rs that have a separate grid of assigned parking. So without looking at them, it's difficult for me to really say anything useful. Because the process, I would think that the process of attaching a parking unit to or area to a unit would be set forth in the CC&Rs. And so if a neighbor is just squatting on the buyer's structure, then maybe the action needs to be directed toward the neighbor. And I would think that the HOA through its enforcement rules would have an easier time to do that. They could start issuing fines to the squatting garage neighbor.
Yeah, I think the moral of the story is when you're selling a condominium, and especially if it's not necessarily an attached parking structure, you need to review the condominium plan to make a determination which parking structure or assigned space is associated with that condominium. And it could be storage spaces also that may be associated with that particular unit. Is if you don't address that up front, later on, the buyer is going to find out that they're not entitled to usage of that space, and it's going to be a problem. And who are they going to blame? It's going to be us.
Yeah, well, and more importantly, not so much try to make that determination yourself, but to make it clear, and then obviously in writing to the buyer, hey, here's the issue. You should figure it out. If you don't know how to figure it out or don't understand the CC&Rs, I'll point you to an attorney that will be able to help you.
Yeah, it's always difficult for us to tell a buyer that we don't understand what we're doing. That's the dilemma, Mark. They expect us to know everything that you know, which is a problem, as a matter of fact. And then what used to be available, title policies, will not even insure against any claims or inappropriate usage of a parking structure or assigned spot. We used to be able to have that included in the title report, and that would provide the buyer with protection. But now title companies are reticent to even include that information in their title policy to assure us or assure the buyer that they have insurance against a claim or the proper usage of that spot. So that's always been a problem. And then, I'm sorry, did I answer your question? Do you have a question? And then one thing I wanted to ask you about, we do 400 residential leases a year. And the best way to avoid litigation when we have applicants?
Oh, again, the firstly to take all applicants, right? And don't, as I mentioned a bit early, if somebody inquires about whether the property is or the owner will agree to Section 8, any kind of subsidies, you can't discriminate based on that. So just take the applications and submit them to the owner for a determination. If the owner starts to say, well, I want to make a selection based upon housing issues, then just on a fair housing violation, then you got to tell the owner, listen, you can't do that. And if the owner, and we just have, I'm dealing with one right now where the seller was adamant that they didn't want to deal with Section 8, and the results was ultimately they had to give up the listing. They had somebody call and ask about it, and he said, no, I don't want any Section 8. And the brokerage actually had to end up letting go of that listing, but it was by that time it was too late because then the applicant had already filed a housing violation claim.
So the recommendation possibly would take the applications in the order in which they're received. The seller, or excuse me, the landlord should have criteria that they should be applying consistently to every applicant. And it's defensible, right? If you meet the criteria and you're the first person to submit your application, then you're going to be awarded the unit. Otherwise, if you don't meet the criteria, we move on to the next applicant.
Yeah, no, it could also be that, you have somebody that's on a property that where the owner would prefer not to have dogs. And you have one applicant who says, I've got my 150-pound Rottweiler named Guardian that I want to bring on, and oh, don't mind Guardian, he's only bit 3 people before, he's better now. And so but my doctor says that Guardian makes me feel better. So now you've got, a service animal issue, but then you've got 3 other applicants that don't have a request for service animals. So obviously the owner is going to want to accept one of those others to avoid that problem. But then, you want to make sure that you have a clear record that the owner saw all the applications and the owner made a selection. If there's multiple applications on a housing issue and the owner selects somebody who doesn't have whatever housing issue that they're uncomfortable with, those are really hard to be able to establish a fair housing violation. Usually where that comes up is there's only one applicant that has an issue, and then they just say no, and then there's no other applicants that are pending, and then it's much easier to show a housing violation in that kind of scenario.
So there are people who want to have a daycare in their rental property.
So the question comes up about daycares. Usually what takes place, somebody signs a rental agreement or a lease agreement, and then they notify the landlord that they operate a daycare.
Or before even they sign
Even
it.
before they sign.
Decide.
So obviously, if you would address that, people that are at least honest enough to tell us in advance that they intend to operate a daycare out of the rental property, that's not a reason for termination or for not granting them credit, I would assume.
Well, I don't know. I mean, somebody who is operating a property as for commercial purposes, that's not I don't see that as being a fair housing issue. Even if it were, I would say that even if they say, hey, listen, I'm going to rent this property to do a drug rehab, that's again, it's a commercial use. And I know that, there are health and safety code provisions that presume that type of facility is still residential use, even though we all know it's not. I haven't had any cases on that issue, but I would say that, if that's something that is a concern for an owner, that I wouldn't have any hesitation on denying a lease application or recommending that the seller is free to deny a rent application because they're going to make commercial use of a property. I mean, those kind of facilities wear down a house faster than just ordinary family living.
Yeah, usually for small rental properties, it seems to be something that's the state and or municipality agrees that if it's 6 people or less.
Yeah, it's six rooms or 6 beds or less, then it's still presumed to be but then again, that presumption applies for in certain it's I don't know that presumption would prohibit an owner from saying, listen, I don't care if it still is presumed to be residential use. I know it's not, and I don't want that in my house.
So if somebody they're telling us up front that they're going to operate a daycare facility and they're going to be providing care for 6 children or less, and it meets the guidelines in regards to what is square footage, what would you suggest that we use in terms of, or the seller, the landlord should submit in terms of a denial? What do we tell them why we're not granting them credit?
Well, I don't know that you necessarily have to give a reason. We selected somebody else, is always, or on that kind of scenario, I would say that even if it is 6 kids or less, you just don't want to have a daycare in there. I don't see a problem with saying denying your application because I don't want there to be commercial use of my property.
I said, okay.
It becomes another issue too, with being able to get insurance. You have to take in a certain different account. Renter's policy really, it may not be effective in that kind of scenario. So it isn't without risk to an owner to allow something like that to be on the property.
Christine, you had a question?
Do landlord have to apply for some kind of special permits to rent out for commercial, like assisted living for 6 beds or more?
Well, that's different than what I'm talking about in regards to people providing daycare. So that's a good possibility. Do they have to have a permit to operate a commercial facility within a residential area? I think Mark is suggesting that's the case, quite possibly.
Well, and those kind of when it's approved by the county or by the state to operate one of those facilities, all my experience has always been those are properties that the operator owns, because it would be, I haven't gone through the process, but I think it would be unwieldy for somebody to try to get a house approved where they don't have control over it yet. And so and then if you run the risk of, the landlord not wanting to rent the property, now you've gone through all this process of, as an operator, to get that address approved, and then you're not in control. If the landlord says, I'm going to move back into the property, you got to leave.
And another one was like, sometimes when your title report has the square footage as 1,000 and then the MLS has it as 900. I know you said you can choose where you're getting your information from, but would that be okay even if there's a discrepancy from the title report versus from
Well, I assume the title report's going to be talking about the assessor's square footage. Well, maybe you could address that, Mark. So we have discrepancies in regards to square footage. Sometimes the assessor states a certain value, and then we get other numbers. But if you have documentation in terms of the square footage, an appraisal, something like that, as long as you have some basis for it, not just the seller's estimate.
not seller's estimate.
Yeah, well, that's what sellers will tell you. They think their house is larger, so they want to tell you to say 3,000 instead of 2,500 square feet. Now,
Yeah, the assessor's information is notoriously inaccurate. Things are added on. You've got improvements that you pull a building permit for, but it doesn't make its way to the assessor's office. So if the seller tells you, and we have this happen an awful lot, we added on, it's not 1,500 square feet, it's 1,780. Then if there is a discrepancy, I think you, as a selling agent, you should point it out to your buyer. Hey, the seller's saying one number, but I'm looking at the assessor's number or the title report, and it says a different number. You want to figure that out. If it's taking a listing, if you're not sure which square footage number is correct, then I would select one of them, 1,780 per seller, but then in the notes say, the square footage listed in the assessor's number is different than the seller's estimate.
Mark, we're at 10:58, so we're just letting you know you have 2 minutes until your next meeting.
Okay, yes, you can actually submit documentation and have them update that information. So, Julia?
Going back to denial of rental, if it's a roommate, can we say the owner prefer the tenant to be qualified on their own? Because like college students, they usually have a cosigner. Can we just deny based on that? Or how to deny the college student?
How do that?
Well, I think,
Hear that, Mark?
yeah, the rent subsidy question is different, right? Because you can't, so the law says you can't discriminate against the tenant from having rent subsidies, Section 8 or what have you. But the law doesn't require that an owner go through the process of getting their property approved for subsidized housing programs. And so you can't say don't submit an app because you have a rental assistance program, but the owner can certainly say, I don't want to participate and I'm not going to rent with you. And that's fine. So you have to be very careful in that scenario. And I would say again, and Richard, I hear what you're saying. They don't like to hear it, but in this kind of circumstance where the ADA or anti-discrimination laws are so complicated and have some penalties, that would be a scenario where I would say, I'm an agent. I'm not an ADA attorney. This is what they want to do. You should go talk to an attorney that's familiar in these issues and let me know how you want to respond.
I think, I know we're out of time, but I think she's suggesting if I have multiple students wanting to apply for a rental unit, how can we deny them without saying, I don't want any students? That's what her question was, correct?
Oh, for being a student? Oh, well, yeah, I don't think that, last I checked, students aren't a protected class, but California is ever changing. So I think if it's just students and you'd rather not have, 5 people in splitting a rent, that I wouldn't worry about denying that.
Okay, well, very good. Very interesting. Yeah, that's up to them now. All right, go ahead.
Quick yes or no if you have time, Mark. I have a lot of questions about probate. I'd like to add trust deeds as a service to differentiate my business. Is that something you see for a home warranty, or is that something you see that if I got involved with a friend who's starting up a trustee business? Is that something that you see has legs to run, or yes or no?
I didn't hear all that question. Can you repeat it for me?
Come on up, Rick. Come up.
Just a quick question about probate. I want to kind of improve my business and maybe differentiate myself a bit. If is that something home warranty might cover in the future, so that we can get rid of this terrible probate system, get some trust deeds going with people? I have a friend who does trust deeds, and she wants to partner up and kind of offer that as an additional service. When somebody has property in California, it's really good if they have a some kind of trust more than just a will. Any thoughts on that? Yes or no? Is there legs on that for an additional
Oh,
service?
that how if the question is, how are people going to hold property? Really, it's unique to every individual circumstance. We've got death on deeds or deeds on death now in California. You can, as you mentioned, hold property in trust. They just increased the probate level much higher. I want to say it's like 750 now, where it was 60 grand or whatever in the past. So it's hard for me to give you a generic answer to that, because it really is unique to the individual person.
Cool. Thank you.
All right.
But I got to go.
Okay,
I
Mark,
got people
David,
waiting
thank
on
you
me.
very much. We
My
understand.
pleasure. Good seeing you all again.
Thank you once again. We appreciate your time.
All righty. Bye-bye.
Absolutely. Everybody have a great day. Thanks so much, Sharon, for having us. And let's do it again next year.
All right, thanks once again.
All right.
I have two things I want to add to that, that they have, I'm sure, didn't have time. And this is, one where I get on my soapbox, and I really, because I see a lot of lawsuits of agents getting in trouble. And one of the biggest ones is because you're picking out the coverage for the buyers on the home warranty. Everything we have has those little QR codes where you can download the PDF. Always send your buyers the PDF. Tell them they have X amount of dollars the seller is going to be paying for. They can have every bit of coverage they want. They just pay escrow the difference when it closes. Escrow will charge them the difference. Don't pick it for them, because as soon as the pool gets left off, or the air conditioning gets left off, something gets left off, they're going to come back for you, and then you get what we call a commissionectomy. So always send them this email. Send them the brochure. Let them pick it out. If they want to pay the difference, great. If they don't, that's fine too. They get what they choose. Make sure they reply to you with an email telling you what they chose, and that is going to save you a lot of problems someday. I see, I'm going to give you one example. We have something called appliance limit upgrade, where with appliances, we normally cover up to $5,000 for replacement. But a lot of the homes, especially in South County, have built-in refrigerators and high-end appliances. 5,000 is not going to go very far on replacement. But if an agent didn't order the appliance limit upgrade, which gives them 10,000 towards replacement if it can't be repaired, I've seen twice where the buyer has gone back to the agent wanting that $5,000 because it did not get ordered. So take it off your shoulders, put it on the buyers, let them decide, and that'll save you a ton. Okay, one last thing I want to hit, and this is, I'm going to jump over to NHD real fast. They did change the fire maps recently. A lot of the homes, and a lot of you guys who farm, you're used to, yes, this is a fire zone, no, it's not. Well, there were huge changes, and a ton of homes in this area have been added to the severe fire zone. I've had a lot of people send me reports, and of course, we'll show yes. We're a huge Fortune 500 company. We have to do it right. So just letting you know, if you get a report or you want to check on an address, send me the address. I'll look it up for you real fast and tell you.
So you'll tell us also if there's a local ordinance too.
And that I don't.
All right.
No, I will tell you, yes, it's in a zone, not, and I'll send you a picture from the map. And I can actually send you the link where you can look up any home you want. But it's just really important, those two things, because there's a lot going on with the fire changes right now. So I just wanted to warn you, what might not have been in the fire zone now might be, because those embers can travel five miles easily. Okay, thank you guys.
Two things I want to correct about today's presentation, the BRBC, it is a 3-month duration of time. He said 2 months, so it's still 3 months, and it hasn't changed. If you take a BRBC for a period beyond that, then it will be invalid, it's not enforceable. So you take it for 4 months, it's not enforceable. You can extend a BRBC, so that's permissible, do that before the expiration. And then the removal, previously in section 3G3 of the RPA, there used to be language in there until June of this year talking about the fact that if you request more money as the buyer's agent in section 3G3, money or compensation greater than what's in the BRBC, you're not entitled to anything. That language was removed. But in no case are you ever entitled to more compensation than what's on the BRBC, no matter what the sources are also. Any questions?
Would you please say it again, Hala? Would you please say
There was a
it's
question.
2 months or 3 months now? I'm sorry.
3 months. So when you take a buyer representation compensation agreement, BRBC, you cannot have a period exceeding 3 months. Otherwise, it's invalid and you're not entitled to compensation.
I see.
And you must be specific on the BRBC about the amount you're going to earn. You can't say, well, if you put 2.5% in there and then you state, if the seller is only going to pay 2, that's all you have to pay. It must be specific. Otherwise, you will not once again be entitled to compensation. Then what you can do, assuming you have, or the client has trust with you, the buyer has trust with you, you can issue a credit after the fact or during the transaction. So you're entitled to do that. So there's no prohibition against doing something like that. Just don't specify that in the BRBC.
So what he was saying about 2 months, or did I hear it wrong?
I think that was just a mistake.
He said 2 and then
He said 2.
corrected
No, he did say 3. Okay, I missed the correction then. Okay, it's 3 months. So no more than 3 months for the BRBC. Okay, any other questions, Roya?
No, thank you so much.
All right. Well, thanks for coming, everybody. Sharon, thank you. Appreciate everything. Yes. Oh, I'm sorry. Yes, DRB. Yes. Come on.